Seventh lecture note. The title of this lecture note is The Interpretation of the Law. We are going to look at this in four aspects. The first aspect, the concept of legal interpretation. The second, the types of interpretation of law. The third, ways of interpreting the law. The fourth, the interpretation of law by volume. Let us look at the first aspect, the concept of interpretation of law. The science of interpreting texts, including legal texts, is called hermeneutics. Legal hermeneutics develops problems of interpretation of various legal texts, terms, concepts, and legal norms. As an integral part, it includes the theory of interpretation of law. The interpretation of law is a clarification and explanation of the meaning of legal norms. The term interpretation of law is always used in this context. The term interpreter refers to a person who understands text. To interpret is to reveal what is not clear at first glance. Interpretation of the law implies clarification or clarification of the meaning of legal norms. The alternative conjunction or is used here due to the fact that clarification may not always take place. Clarification is the disclosure of the content of a rule of law for oneself. That is, the interpreter is supposed to identify the meaning of the text of a legal norm for himself. Explanation is the disclosure of the content of the rule of law for others, that is, the interpreter's transfer of the meaning of the text of the legal norm for other subjects of legal activities or rhetoric. The interpretation of the law is consciously willful. In the process of applying the law, its interpretation is always carried out. That is, if it is an interpretation on the part of the law enforcement officer, regardless of whether the law enforcement officer implements the legal norms expressed in clear terms or faces so-called evaluative and other unclear or inaccurate provisions in the content of the norm. In situations other than law enforcement, its interpretation may not always take place. For example, it is absent if the participant in the legal relationship behaves lawfully but does not know about the existence of the observed norm. Thus, the interpretation of law is the intellectual and willful activity of subjects of legal relation to clarify and or explain the meaning of texts of legal norms. Let us now look at the second aspect, types of legal interpretation. There are two main types of interpretation. The first, official, and the second, unofficial. The official interpretation is given by specially authorized representative of state bodies and is mandatory for the law enforcement officer. The official interpretation, first of all, is divided into two types. The first, authentic, from the Greek word authentikos. Authentic, coming from the original source. Interpretation carried out by actual subject who created the interpreted legal norm. The second, delegated, sometimes also referred to as legal, interpretation of other activities authorized to do so. Let me come again. On interpretation of other entities authorized to do so. There is also a different classification of official interpretation on 1. Causal, from the Latin casus case, that is, for specific case. And the second, normative, for all cases and persons falling under the jurisdiction of the subject of interpretation. Informal interpretation, in turn, is divided into three types. The first, professional, given by persons professionally engaged in legal activities, that is, investigators, lawyers, judges, prosecutors, legal advisors. The second, Doctrinal interpretation carried out by scientists and teachers within the framework of the system of scientific legal ideas. The third, ordinary interpretation carried out by persons who have neither scientific nor professional knowledge of the law. Let us look at now the third aspect, ways to interpret the law. The method of interpretation of law can be defined as a set of means or techniques of understanding the meaning of the text of a legal norm. The main ways of interpreting law include grammatical, historical, and logical. Method 1, grammatical. In other words, philological, linguistic. It involves semantic, morphological, and synthetic analysis of the meaning of the legal norm. It is related to verbal text, the sign of system. For example, we cannot interpret an image in this way. A language is taken, such as Russian, and interpretation is performed using it. Method 2, historical. Sometimes this method is referred to as historical, psychological, or historical political. We are talking about situations when, in addition to grammatical analysis, the question is raised in the process of interpretation. What was the author thinking when writing a normative text, or what guided the collective subject of lawmaking? In what social, political, historical context was the corresponding text created? Method 3, logical. This is an interpretation using the 5 laws of formal logic, in which we use the rules of construction and transformation of statements that preserve the truth value regardless of the content of concepts included in these statements. In addition, in this situation, we can also talk about the use of modal logic, a special place in which is occupied by deontic logic of norms. With its help, the interpreter makes a conclusion, for example, about which of the special standard normative terms that is required, prohibited, allowed corresponds to the terms may, not, may, necessary, not at all, and so on. In addition to the above, the scientific literature quite often also identifies systemic, functional, and axiological ways of interpreting law. Let us look at the fourth aspect, interpretation by volume. In terms of scope, the interpretation of legal norms is divided into literal, that is adequate, distributive, that is expansive, and restrictive. Not only the explanation may vary in scope, but also the clarification that occurs within the various modes of interpretation. In the case of literal interpretation, the content of the text of a legal norm disclosed as a result of interpretation corresponds to its literal meaning. As an example, Article 81 of the Constitution of the Russian Federation states that the president is elected for a term of 6 years. In the case of a broad interpretation, the content of a text of a legal norm disclosed as a result of interpretation is broader than the letter of the text. For example, Article 120 of the Constitution of the Russian Federation states that judges are independent and subject only to the constitutional and federal law, while in practice they are required to take into account both the laws of the subjects of the Russian Federation and bylaws. That is, the term law in this situation should be interpreted broadly. A restrictive interpretation is one in which the content of the text of a legal norm disclosed as a result of interpretation is narrowed and becomes less voluminous than the letter of the law. The basis for a restrictive interpretation is the existence of a special or exceptional rule that makes an exception to a more general rule. For example, according to Part 2 of Article 38 of the Constitution of the Russian Federation, caring for children and their upbringing is an equal right and duty of the parents. However, in reality, taking into account the provisions of family law, we are talking about minor children, since able-bodied children who have reached the age of 18 must take care of their elderly disabled parents themselves. Each word of the language has several meanings. For example, the word law itself is understood both as a right in the objective sense, as a set of rules, and in the subjective sense as a legal person. And each time you have to choose the correct meaning of the word in this context. And with that, we come to the end of the 7th lecture. Thanks.